Last night I got home, and between now and then I learned that our president ordered the bombing of Syria. His lawyers are appearing in court in the Southern District in New York, and he himself sent a lawyer to his lawyer's hearing. And it looks like the Justice Department is heating up, and this morning, we'll get to this a little later, the word kakistocracy has now been used to describe the current administration. You can Google it if you want. So in many ways, it's both the worst of days and the best of days for investigative reporting and for the news in general. Once again, the president and things around him are dominating the news and the issues around him as well. And as we gathered here, as I mentioned yesterday, and we were talking about it to a certain extent, it is the 50th anniversary of the journalism school. We're faced with new issues, and many of the new issues also have a long history to them. In some ways, it seems to me every now and then, after almost 50 years in the business, that I thought the past was prologue, but it looks like it's repeating itself. And it's those dilemmas around issues like the First Amendment and what we can do and what we can't do, the nature of investigative reporting and where we are now and the situation are all in some ways happening again. The same issues are being fought over in many ways, and we hope to address them with the appearance here on at the podium this morning of two deans. The dean of the journalism school, Ed Wasserman, who will talk for a while, and he'll introduce Dean Erwin Chemerinsky. Or did I get that right? Chemerinsky, sorry. I keep mispronouncing his name. He said he doesn't care, but you know. And again, one of the curious phenomenon of all of this is that two of the major issues that we're going to be looking at today, one we'll call hashtag #MeToo, and the other, the president, Russia, and their relationship, all come together in the White House in really a way that just overwhelms, I think, someone of my age, in fact. The amount of information coming in every day, the developments become more and more confusing in certain ways. What is true, what isn't true, what's going to happen, is there going to be, is this administration going to make it, is it not going to make it, what's going to happen with issues like the Supreme Court and how that will affect us long term. These are all things that we'll be talking about, as well as the hashtag #MeToo story and its consequences. Those of you who were here 4 years ago in this room, on a panel right here, a participant, Jim Chanos, in a discussion of the gambling capital of Macau, said some things referring to the casino empire of Steve Wynn. And as a result of what he said, Steve Wynn later would sue him for libel in federal court in San Francisco for what he said at an academic conference. And just to remind you, Gary Bostwick was involved in defending him. He's over there. Because of the SLAPP statutes in California and an intelligent judge, the case was thrown out very quickly, within 90 days, and then he was allowed to refile. It was thrown out again. It was taken to the Ninth Circuit and thrown out again, if I'm correct. Is that correct, Counselor? So, and there's no way for us or for in Mr. Chanos' case in California, he got his legal fees reimbursed, I believe, right? Yeah, so, which was okay, but I guess there's no sweeter revenge than Mr. Wynn is no longer the CEO of Wynn, his company. In fact, has sold his stock and is now facing, if you will, universal condemnation for what? For the serial harassment and predation of women who were in his employ. And so that seems, somehow karma seems to have set in. A round of applause for karma. Okay, so I want to introduce Dean Ed Wasserman again, who spoke briefly yesterday, who's going to address some of these issues and introduce his fellow Dean, Erwin Chemerinsky. Dean Wasserman.
Thank you, Lowell. And thank you all for coming out today, this beautiful, lustrous Saturday. There is a third dean with us today, my friend David Boardman, dean of my counterpart dean at Temple University, who will be talking to Richard Gingras a little later. I just want to say thanks to those of you who have been supporting the IRP and supporting the J School, particularly Richard Logan, head of the Reeve and David Logan Foundation, and John Logan, head of the Jonathan Logan Family Foundation. This is a special, this is a special event of the school season. It's a thrill to see so many people whose work I have long admired in one place. And it's a chance for me to reflect a little before practitioners, distinguished practitioners on the state of journalism, which Lowell has been kind enough to give me an opportunity to do in the past, and I'm happy to do it again. So let me just run through some things that I think are that are notable about the current situation. I would say that by any standard in reviewing the extraordinary work of investigative reporters since the last time we gathered a year ago, the most consequential coverage has been the unearthing of sexual wrongs that gave rise to and continues to fuel the Me Too movement. I cannot recall a comparable moment of genuine social transformation that has been so thoroughly reliant on the enterprise of reporters. It's really a cause, I think, for pride. It's also a reassurance of the continuing capacity of the press to have genuine social impact. Me Too has unfolded in good measure as a response to realities that came to light thanks to reporters, and realities given a wholly different weight thanks to the reporting that then in turn energized the movement. But let me just draw some lessons from Me Too. It's a story that in many respects defies the usual standards of newsworthiness. News is usually driven by how new something is, whether it's illegal, whether it's a plain breach of accepted norms, and how little known it is. But that's not the case here. The big takeaway here is the harm was enough. Harm is enough to get the media to pay attention. It doesn't have to be new. Oh, the casting couch is as old as Hollywood, right? The overweight executive chasing his young assistant around the desk has been a trope in single-frame cartoons as long as they've been there. The harm doesn't have to be new. Wrong is enough. In fact, if the wrong is a long-standing one, that's even worse. Second point, it doesn't have to be illegal. Sometimes it was, but if the harm wasn't illegal, that might even be worse. It goes back to the old standoff between law and ethics. The ethicists say they're in the business of telling lawyers what the law ought to be. In this respect, the media are the ethicists. And thirdly, it doesn't have to be little known. If the wrong is widely known, that too is worse. It means that the public either condoned the wrong or hadn't been forced to examine up close how people were damaged, how their aspirations were crushed, how their lives were deformed. So let me just say congratulations to those of you who have had a piece of this story and continue to. You have, in my view, helped propel a process of cultural transformation here and abroad that was sorely overdue. I know this is the subject of the panel later on today, but I wanted to tee it up in those terms because I have not seen an instance where a transformation of this scale and scope could be laid almost entirely to the enterprise of reporters. Now, as to the overall state of play in the news media, it's a nettlesome moment. This conference is literally in the shadow of Trump. I, like everyone else, will talk about Trump. He'd want it no other way. A year ago, I joined you in taking some satisfaction in the denunciation of the press. Now, I'm not so sure Trump is good for us. At a recent gathering here of Capitol Hill correspondents, I suggested that Washington was suffering a slow-motion stroke. And as with any stroke, the questions are, how serious is the impairment and how permanent? Now, I was talking about government. But let me take that in a different direction and ask the question, what's Trump's effect on the media? Or let me put it a different way. What will American journalism look like after a second Trump term? It's not that far-fetched. Maybe I'm still reflecting or trembling of the consequence of reading Thomas Frank's piece in Harper's, where he speculates on the possibility, he believes, if the economy remains strong, the likelihood of a second Trump term. But what I want to do is ask whether, and here I realize I'm omitting many other problems we could talk about in the news, pauperized newsrooms, heavy-handed corporate meddling. I want to focus on the bad habits the media are, in my view, developing in response to the age of Trump. And here are some thoughts, and I suspect not all of them you will agree with. First, the media have made and continue to make Donald J. Trump the center of public life in a far more suffocating way than any previous president, ever. The coverage hasn't been positive, but it never was. That's how he got elected. And that attention is what continues to give him stature and importance day in and day out. And for all his manifold sins and lunacies, it will entitle him to take personal credit if voters believe that, on balance, the country's doing well in 2018, regardless of whether it's because of him or in spite of him. His rule is sustained by the news media. Now, paradoxically, this prominence comes with almost knee-jerk disparagement, much of it apparently derived from visceral distaste. Now, I'm certainly no fan of Trump, intellectually, morally, temperamentally, in terms of background, overall capacity. He has no business in the White House outside of a guided tour. But when I think back on the warmongering, deceitful, unquestionably criminal, massively destructive presidents I've seen in my lifetime, and the millions who suffered and died needlessly because of their actions, I recall that these were presidents whom the media cozied up to and not infrequently abetted. So I have to wonder why the loathing for Trump is so vast and so heartfelt. Hey, by this time, W had teed up 2 wars. You really think Trump reads less than Reagan, is dumber than Ford, abused more women than Bill Clinton? No, there's something personal about the insult many of us feel about his having the highest honor the country can bestow. But distaste is no judgment for news judgment, rather, is no substitute for news judgment. And for the 40% who either like the guy or don't think he's all that bad, a news media that is united in its judgment that he's a villain and shapes its coverage to sustain that judgment is sure to further inflame a long-term cynicism about the media in their view. Now, posing the media's choices between collaboration and resistance makes the challenge of passing along standards of professionalism to my journalism students tough. So my point, don't pander to passion, cover the policies, not the man, there where the harm is being done, much of it without his knowledge, let alone direction. Now, thirdly, that means halting the practice of letting the White House set the news agenda, notably via the press's high-velocity attention to social media postings. That news agenda is the most powerful tool the media wield. The real estate on the home page or front page or the top of the newscast of a small number of legacy news organizations is the most influential place to signal to the public what matters most, and it shouldn't be surrendered to utterances without significance, even when they're sensationally stupid or cruel. Weaponizing social media by chasing tweets and responses as if they constitute genuine breaking news allows a self-serving agenda to eclipse the most dispassionate and thoughtful appraisal that professional journalists are trained to perform when deciding on public significance. Trump is clickbait. He's a compelling figure. He's a riveting figure. He draws a crowd. That's absolutely key to his success, and it's why, as Lowell recalled yesterday, Les Moonves said, Trump may not be good for the country, but he sure is good for CBS. So unless we mend our ways after 8 years, those bad habits developed under Trump will have become, I fear, standard practice. Now, I understand this is a frustrating time, largely because of the emasculation of our political culture by single-party electoral dominance. The mechanisms by which news media have historically had impact on governance have been disconnected and disabled. Consider the whole notion of whistleblowing. I know that'll be a panel later on today as well. When the referee blows the whistle, play is supposed to stop. When the potential crime victim blows the whistle on the street, the police are supposed to come. The whistle inaugurates a new phase in the civic response to wrongdoing, in which problematic conditions are identified, recognized, halted, and adjudicated, and correctives are applied. But what if the play goes on and the cops don't come? The wrong is exposed, but officials don't resign. Hearings aren't called, indictments aren't handed up. The political system is immobile because most of the players with the power to respond have no interest in doing so. We've got that now, but that doesn't, in my view, change our duty as journalists, which is to keep our eye on the search for realities of greatest public significance and bring them to light in as thorough, honest, and compelling ways we can devise. The press must not succumb to the temptation posed by an appalling presidency to turn itself into a medium of reprimand and ridicule, even if that sells papers. If I can steal a quote from my old friend Marty Barron, whom I've known since before he was a virgin, who told his Washington Post newsroom, "Don't go to war, go to work." So I leave you with that, and now it's my honor and my privilege to introduce your next speaker, Erwin Chemerinsky. I beg your pardon. Sorry, Erwin. I suspect you're used to that, right? When Erwin Chemerinsky became the 13th Dean of Berkeley Law last July, there was a palpable sense of relief and satisfaction on campus. His predecessor had been bounced in a squalid early Me Too affair that was handled sufficiently badly to end up costing the jobs of both Berkeley's provost and chancellor. Erwin himself was no stranger to controversy. When he was named founding dean of the law school of the University of California, Irvine in 2007, the chancellor there felt enough heat to almost immediately rescind the appointment because his conciliaries advised him Erwin was too liberal for Orange County, California. An outcry ensued. The chancellor came calling, they talked, and Erwin was reinstated. By the time he got here last fall, it was just in time for a rather fiery dust-up over free speech on campus, which Chancellor Christ referred to yesterday in her talk to us. And I have to say, having listened to Erwin give his talk on the state of the First Amendment to a number of audiences, it was sort of an astonishing and reassuring reminder of what good, cogent, lucid legal analysis looks and feels like. It was, people were very inflamed, and Erwin reminded us what the boundaries are on free speech on campus and why they're there, what the First Amendment is here for, and he did it in such a kind of gentle and almost tender way that there were audiences of people that came predisposed in quite another direction left convinced. I was enormously impressed. And I'm not surprised, Erwin Chemerinsky has a national reputation for his work in federal law, constitutional practice, and civil rights and liberties. National Jurist magazine ranked him first among the 23 law professors you should take before you die. I give you a moment to sort of think about that. I think you have to be, you have to be a law student to understand that, your time is coming, days are short. But you won't rest easy until you have a chance to take Erwin's course in civil procedure. In the 2012 issue of National Jurist, he's also listed among the 25 most influential people in legal education. And along with those accolades, I'm obliged to add the testimony of my daughter, who's finishing law school back east, who told me that his book on constitutional law saved her life. She is not notably generous with praise. Before he came to Berkeley last year, Erwin was from 2008 to 2017 founding dean and distinguished professor of law at the University of California, Irvine. Before that, a professor at Duke from 2004 to 08, and from 1983 to 2004, a professor at the University of Southern California Law School. He's the author of 10 books, frequently argues appellate cases, including before the U.S. Supreme Court. We've asked him to give us a look ahead to the First Amendment cases that are circling for a landing in the courts, to get a clearer sense of how the legal terrain is shaping up for journalism practitioners, among others. It's my pleasure to introduce to you Erwin Chemerinsky.
Thank you so much for that incredibly sweet introduction. It's really my honor and great pleasure to be at this terrific conference. What I want to talk about is the landscape with regard to the First Amendment, freedom of speech, and freedom of press during the Trump era. I think this is a unique moment in American history. I want to make 3 points. First, we have a president who's more hostile to the press than any before in American history. Second, we have a Supreme Court that's more protective of free speech than any before in American history. And third, the internet and social media create issues with regard to free speech and free press that have never been faced before in American history. As to the first of these, Donald Trump's hostility to the press is familiar to everyone in this room. Now, he's not the first president to express publicly or privately hostility to the press. Thomas Jefferson did. Richard Nixon famously, infamously did. But I know of no president before who has ever referred to the press as, quote, disgusting, disgraceful scum. I know of no president in American history before who's ever said that the press is the greatest threat to the American people. We've seen Donald Trump take some actions against the press. Press briefings have been held where those who are not favorable are excluded. He's cut off individuals from his Twitter feed. He doesn't like the coverage they provide, something that's now being challenged in the courts. Some of what Donald Trump has threatened to do is beyond his power as president. He said as a candidate, and again as president, that he wants to reform defamation law to make it easier for people to sue and recover. Here he simply reflects his ignorance about the law and the Constitution. There is no federal law with regard to defamation. Each state has its own law with regard to libel and slander. It's the United States Supreme Court, starting in New York Times versus Sullivan in 1964, that said that the First Amendment limits the ability of a state to recovery for defamation. On the other hand, my great fear in the remaining years and months of the Trump presidency is how his administration might come to use the Espionage Act of 1918. It is, I'm sure you know, a very broadly worded statute that allows the federal government great power to go against journalists who reveal what are regarded as national secrets. Since 1918, there have been 12 prosecutions initiated under the Espionage Act. 9 of them were begun by the Obama administration. I have worried since the start of the Trump administration how that will set a precedent for how the Trump administration might go after the press, go after it where the sanctions can be imprisonment. At the same time, though, as I said as to my second point, we have a Supreme Court that's more protective of speech than any we've seen in American history. We tend to forget that through most of American history, the Supreme Court was no friend of freedom of speech and freedom of the press. From 1791, when the First Amendment was adopted, until 1919, the Supreme Court decided virtually no cases about freedom of speech or freedom of the press. It wasn't found to apply to state and local governments until well into the 20th century, and the Supreme Court wasn't checking the federal government, even when, as during the Civil War, it was engaged in repressing speech. The initial Supreme Court cases about speech in that year, 1990, came down against freedom of expression. The most famous initial case was Schenck versus United States. You might remember it involved a man who circulated a leaflet arguing that military conscription was a violation of the 13th Amendment as involuntary servitude. For just this, he was convicted of violating the Espionage Act. Now, there wasn't an iota of evidence that his leaflet had the slightest adverse effect on military recruitment. Nonetheless, the Supreme Court upheld conviction and a 10-year sentence. This was the case where Justice Oliver Wendell Holmes famously said, "There's no right to falsely shout fire in a crowded theater." Schenk's speech was the very antithesis of shouting fire in a crowded theater. It was a legal argument, and yet the Supreme Court upheld the conviction and sentence, as it did against many others in those years. During the McCarthy era, the Supreme Court repeatedly upheld convictions, again for speech that was tame and ineffectual. The leading Supreme Court case during the McCarthy era, Dennis versus United States, involved individuals who organized to teach the works of Marx and Lenin. There was no evidence that their teaching had any threat or posed any risk to national security. Yet the Supreme Court, in an opinion by Chief Justice Fred Vinson, upheld their convictions under the Smith Act, saying that when the evil is as grave as the overthrow of the United States government, there doesn't have to be any proof whatsoever that the speech will have an impact. It's against this context and against this backdrop that I can say without question, we have a Supreme Court that's more committed to free speech, I hope more committed to free press, than any we've seen before. Let me mention a couple of examples. One, a case you undoubtedly have heard of, even if you don't know it by name. The other, a case from just last June that you probably haven't heard of, but have real implications for what we're talking about in this conference. The case from earlier this decade was Snyder versus Phelps. A small church out of Topeka, Kansas, the Westboro Baptist Church. They make it a practice of going to funerals of those who died in military service and using them as the occasion for expressing a vile anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church traveled from Kansas to where his funeral was being held in Maryland. Before the funeral, the members of the church asked the police officers where they could lawfully stand. The officers pointed an area about 1,000 feet away from the funeral service was going to be conducted. Before the funeral, they chanted and sang. During the funeral, they were silent, but they held up signs. That night, his father, Albert Snyder, was watching the news. He was able to read what was on the signs. He was deeply offended. He sued for intentional infliction of emotional distress and invasion of privacy. A jury awarded him $10 million in damages. The Supreme Court, though, in an 8-1 conviction, overruled the liability, ruled in favor of the members of the Westboro Baptist Church. Chief Justice John Roberts wrote for the court, and he said, "The government cannot create liability for speech or punish expression on the grounds that it's offensive, even if it's very deeply offensive." The case from just last June 19th that I want to tell you about was Packingham versus North Carolina. It's a case that didn't get much media attention, which is why I said it might have escaped your attention. Lester Packingham was a 20-year-old college student in North Carolina. He was convicted at that time of taking indecent sexual liberties with a minor. As a result, he's a registered sex offender in the state of North Carolina. In North Carolina, there was a law that said that a registered sex offender could not be on any interactive social media where minors might be present. Packingham got a traffic ticket. He went to traffic court and the judge quashed the ticket. Packingham went on his Facebook page and wrote the words, quote, "God is good." For doing just that, he was indicted and convicted under the North Carolina statute because he's a registered sex offender being on an interactive social media where minors might be present. The North Carolina Supreme Court upheld the North Carolina statute and Packingham's conviction under it. But the United States Supreme Court unanimously declared the North Carolina law unconstitutional. Justice Kennedy wrote the opinion for the court. He began by talking about the importance of the internet as a medium for communication. He said in order for speech to take place, there has to be medium for it to occur. He said the internet is the most important medium for communication developed since the printing press. He pointed out that 70% of American people are on some form of interactive social media. He noted that there are more people on Facebook across the world than the entire population of North America. He said as a result, any government regulation of the internet must be subjected to the most exacting scrutiny. Now, I've praised the Supreme Court for its defense of freedom of speech, but there is hesitation here. There is a but. The Roberts Court has not been protective for free speech, and nor was its predecessor, the Rehnquist Court, when the institutional interests of the government as government have been at stake. Then it's not been a pro-free speech court at all. Let me mention some examples. One that's relevant for the discussion here today concerns whistleblowers. There's a case called Garcetti versus Savalas in 2006. Richard Savalas is a deputy district attorney in Los Angeles County. He believed that a witness in one of his cases, a deputy sheriff, was lying. He wrote a memo to the file to that effect. His supervisor, former student of mine at USC, Carol Nahara, told him to soften the tone of the memo. He refused to do so. He gave it to the defense lawyer, as he believed he was constitutionally required to do. As a result, he was removed from his supervisory position. He was transferred to a much less desirable location. He sued, saying this violated the First Amendment. The Supreme Court ruled against him 5-4. Justice Kennedy again wrote the opinion for the court, joined by Chief Justice Roberts and Justice Scalia, Thomas, and Alito. You'll note that those were the exact same 5 justices, with Justice Kennedy writing that in Citizens United versus Federal Election Commission held that corporations have the First Amendment right to give as much money as they want to have a candidate elected or defeated. Garcetti versus Savalas held that there is no First Amendment protection for the speech of government employees on the job in the scope of their duties. In the year 2000, I was asked to do a study of the Los Angeles Police Department as a result of the Rampart scandal. I learned from many police officers of corruption, of serious crimes going on. Anything that was said to me by a police officer in the scope of his or her duties related to them would not be protected by the First Amendment. The officer could be fired or disciplined. Garcetti versus Savalas is this, the Roberts Court, a pro-speech court, very much undermining protection for whistleblowers. Likewise, the Roberts Court has ruled in favor of the government when it's prisoners bringing a challenge, or students bringing a challenge, or when it perceives national security being involved. Well, this then brings me to the third and final point, and that's the internet poses issues with regard to the First Amendment, unlike those ever seen before in American history. I agree with Justice Kennedy's statement in Packingham versus North Carolina that the internet is the most important medium for speech to be developed, at least since the printing press. It's different than any other media in so many ways. In part, it's democratized the ability to reach a mass audience. It used to be, in order to reach a large audience, you had to be rich enough to own a newspaper to get a broadcast license. Now, anybody who has a smartphone, anyone with a blog, anyone on Twitter with a large number of followers can immediately reach a mass audience. And even if that person doesn't have a mass audience, it can be then passed on by others. The links can be given to the blog site. It can be retweeted. At the same time, the internet has given us tremendous access to information, and information becomes much more permanent. Think about it in the context of defamation or public disclosure of private facts. It used to be that if there was defamation in a newspaper, there would be harms to that, but the newspaper would be the bottom of the bird cage a couple of days later, and you'd have to go to microfiche in some library to be able to access the article. Now, once something is on the internet, it seems to be permanent. It's there forever. The defamatory statement not only can be easily spread around, but also it's there for others to see anytime they want. The internet also has the tremendous benefit of breaking down national boundaries with regard to speech. It is much harder for any country to shut its citizens off with regard to what's going on in the world. When the revolution began in Egypt, one of the first things that the country tried to do was close off the internet. But those with satellite phones still could access it. All of these are tremendous benefits. But there's also cost to speech being so easy and speech being so cheap. It's very easy to engage in harassing behavior over the internet. This, I want to talk about in a moment, is an enormous problem on college campuses. And studies have shown that it's especially women and students of color who are subjected to harassment over the internet. Very private information can be disclosed about somebody to amass information over the internet. There's even a name for this, doxing, where perhaps somebody being transgender or undocumented can be revealed to a mass audience. Revenge porn is a problem that's developed only because of the internet and the ability to reach very quickly a mass audience. There are so many difficult free speech issues under the First Amendment the courts are going to have to deal with in terms of the internet. Let me just rattle off a few of these, and they're all familiar. What about politicians who try to cut off Twitter feeds or other access to their information? Donald Trump is the most famous example of this, but you also find politicians at the state and local level doing this. There have been a number of lower court cases, especially federal district court decisions about this, just in the last year, and they're split. Now, most of those courts have focused on, should we see the president's Twitter feed as some form of public forum? I think courts are looking at it through the wrong lens. As probably everyone in this room knows, there are a number of cases, but when can government officials deny press credentials? And courts have generally said there can't be a denial of press credentials just because the reporter or the news outlet is hostile to the government. Can't be a denial of press credentials based on viewpoint. I think the same principles should be applied with regard to when the president or others cut off Twitter feed. Another important issue with regard to the internet that is written just this week is Congress has amended now Section 230 of the Communication Decency Act. I think Section 230 of the Communication Decency Act is one of the most important provisions with regard to protecting free speech over the internet. If you're not familiar with it, Section 230 of the Communication Decency Act said, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." So when Facebook or Google or any other media service was having information be there, it couldn't be held responsible for what was put there if it was simply being the conduit. However, just this week, President Trump signed into law bills. They were at the House called the Allows States and Victims to Fight Online Sex Trafficking Act, FOSTA, and in the Senate, the Stop Enabling Sex Traffickers Act, SESTA. President Trump signed it on April 11th, Wednesday of this week. And what's meant to be is to say that Section 230 cannot be used to stop prosecution that are involved with sex trafficking or prostitution. Undoubtedly, this is well-intentioned, trying to keep the internet from being used as a way in which sex trafficking takes place. But it is a restriction of speech and will have much broader consequences than I think the House, the Senate, or the President has begun to anticipate. We will see First Amendment challenges immediately to this law. We'll need to see where the courts come out. I think some of the hardest issues with regard to the internet and speech involve college campuses. The image that people have of free speech on campus is so shaped by what went on in Berkeley in the mid-1960s, about students wanting to speak on campus, gaining the right to engage in expression unrelated to what the university activities involved. It was about administrators trying to stop their speech. But now, because of the internet, the distinction between speech on campus and speech off campus has no meaning. What about speech over the internet that's engaging in harassing of other students? I'm going to argue a case in the Fourth Circuit on May 8th that's brought by students of Mary Washington University against the administrators under Title IX for failure to protect them against harassment, not claiming that the university should have stopped anyone's speech or punished anyone's speech, but the duty of the university to protect students when there's online harassment. Or what about when students reveal private information about other students? The traditional answer of the law is to say that the victim should sue in court for public disclosure of private facts. But that's not realistic. When it's private information being revealed, no one wants to then go to court and get more attention to the very things they want to keep private. When can universities punish students for engaging in such behavior? And finally, there's the tremendous power that private companies now have over speech. Google, Facebook, other social media have more ability to control what we receive as information than ever before. They're not governed by the Constitution of the First Amendment. The Constitution of the First Amendment apply only to government entities. But as you think about the hearings that occurred in Washington this week concerning Facebook, the effects that they may have had with regard to the outcome of the election, I think there will be ever more calls to regulate these kinds of media outlets. Will it be desirable as a way of protecting us, or will it be an impermissible restriction of freedom of speech? These are the issues now to be litigated. And as I said, they're all litigated in a context in which I think we have a president who's more of a threat to freedom of press, freedom of speech than we've seen before. I've never been so afraid of the country and the things I believe in than I have been sort of November 8th of 2016. And I think it's in this context that this conference is so important, and I think it's in this context that the words of James Madison are so crucial. He reminded us that knowledge will forever govern ignorance, and that people who mean to be their own governors must arm themselves with the power that knowledge gives. He said, a popular government without popular knowledge or the means to acquire it is but a prologue to a farce or a tragedy, or perhaps both.
Excuse me, Barbara Rabb with the Jonathan Logan Family Foundation and also a non-practicing lawyer, and that was just brilliant. Thank you. I have a question. You talked a lot just now about the various threats that this president poses to freedom of speech. Could you also just comment on how all of these things are being or may be litigated in a context in which this president is also almost on a daily basis attacking the legitimacy and sanctity of our system of justice, of our courts, of our judges? How does all of this come together in a very frightening perfect storm?
It's a great question. If you think about it, in our democracy, there are relatively few institutions that can check the president. I can think of three: Congress, the courts, and the press. This Congress has shown no willingness so far to be a check on the president. Look at the confirmation process with regard to his cabinet nominees, with regard to his judicial nominees. At least at this point, for political reasons, the Republican control of the House and the Senate mean there is no congressional check on the president. Well, that then leaves two other institutions that are a check on the president. The courts, and he's repeatedly been attacking the courts and trying to undermine their legitimacy, and the press, which is sad, and as you know, he's described as the greatest threat to the American people. But if we don't have institutions to check the president, or if he's undermined the legitimacy of those institutions with his followers, what then is there to check the presidency?
Maybe one or two more questions. Right here, there's a question.
Yes, I'm Chris Weicker from CBS News. Internet companies refer to themselves as platforms, not publishers. I'm interested to know, is there a limit, given what they actually practice, is there a limit to that argument, and will it stand up in court?
I mentioned very briefly Section 230 of the Communications Decency Act, and I think that the point of Section 230 was to say that internet providers are platforms and not publishers. And I think that that's had both tremendous positive effects in allowing them to feel that they can be open and there can be robust information there, but there's also deleterious effects. What prompted the change in Section 230 was attempts to prosecute Backpage for what seemed clearly sex trafficking, and they were able to rely on Section 230. Congress has now amended Section 230 to say that at least when it comes to information that might be seen as related to sex trafficking or prostitution, no longer are they simply a platform. They have to be considered to be a publisher. What will be the effects of this amendment beyond just the sex trafficking area? Is this the start of other areas? I am a fan of robust speech. I like the idea that we have Google and Facebook as platforms, not as publishers. But there are consequences to that as well. And I worry of a backlash that may see that the amendment to Section 230 that starts with sex trafficking could expand to other areas. But overall, I think that if we want to have the maximum information available, treating them as platforms is much better than treating them as publishers.
That's probably a perfect place to lead into the next panel, so I think that's a good place to transition. So thank you, Dean.